Good morning, everyone. My name is Cathy Tracey, and I am here with Sandy Andre. We are both labor and employment attorneys at Miller Johnson. We want to thank you for joining us on today's webinar. I hope you're all hanging in there despite this cold, dreary weather we've been having, which only compounds our quarantine misery. Good news is it looks like in Michigan, at least, we're supposed to get above 50 today. So shouldn't be cause for celebration, but I'm looking for all the silver linings I can get these days. The one thing that has really stayed the same during this crazy time is that everything keeps changing. So this morning, we thought we would update you all on the new guidance that we've received on the FFCRA, the ADA, and OSHA. Before we do that, I'm just going to flag a couple things that have happened over the last couple of days. One is last night, the governor issued a new executive order. So she's now up to 59. That one, she just announced, is going to provide for a temporary pay increase of $2 for direct care workers providing Medicaid-funded in-home behavioral health and long-term care services. Also, probably more importantly to the bulk of you, the governor extended the order temporarily expanding unemployment and not charging employer accounts for COVID-related layoffs or leaves of absence. That was supposed to expire just before midnight on Wednesday, but right under the wire, she issued a new order. So now the new order is going to be effective until March 16th, 2020. So with that, I'm going to turn it over to Sandy, and she's going to run through some of these changes to the FFCRA.
Thanks, Cathy. Good morning, everybody. As Cathy mentioned, our goal today is just to bring to your attention some of the new updates from the various federal agencies in a couple of topic areas specific to FFCRA, EEOC, and OSHA updates, but mainly also provide to you some of those resources so that you can bookmark those and monitor those as appropriate for your specific organization. If there are particular areas that are particularly concerning or top of mind for you, you have a general idea of where those federal agencies are, or what method they're using to announce those updates, and so you can keep those top of mind. But obviously, you always get breaking and big development information directly from Miller Johnson. We'll always push that out to all of you. So let's go ahead and get started. We'll turn first to FFCRA Q&As. Next slide, please. And one more. Perfect. So just as a reminder on the Families First Coronavirus Response Act, we all know this, but just looking quickly at the timeline, we remember that it was passed into law in mid-March. The first Q&A guidance was issued a couple of days thereafter on March 26th. And then the final temporary rule was issued by the Department of Labor on April 1st when those paid leave provisions became effective. And so my general advice here is to, you certainly have the ability to read the temporary final rule over and over again. It's a couple of hundred pages and it's a great little read. But generally the Q&A guidance that the Department of Labor provides hits on the general issues and certainly seems to be responsive to a lot of questions that employers are wondering about in terms of how to technically implement these paid leave provisions in their workplace. So we've provided the website there to the DOL guidance. And again, my advice there is to check early and check often, bookmark that website. I will say that answers to the questions have evolved over time. Generally, it's just new Q&As that are added, but some of the answers have, I don't want to say changed, I want to say just become a little bit more nuanced, right, as the final temporary rule was issued in those types of pieces. So as of this week, we are up to 88 Q&As. We had previously been at 79, so we have a handful of new Q&As that we'll just generally touch on at a pretty high level. Next slide, please. So Q&As 80 through 85, I will say there are good news in this list of questions and answers. And the good news is that they all address a central theme. And so if you're dealing with something this technical, you can kind of bookmark, okay, this is the section of the guidance that I would go to deal with these issues. The bad news is that that theme is math, right? And so so for you all tuning in this morning, I don't intend to give anybody a math lesson, but what I will generally say that these Q&As are pretty technical, and they make a lot of sense when you are dealing with an employee who falls into one of these categories that has requested leave. So for example, if you have an employee who's requesting leave under Emergency Paid Sick Leave Act and they have an irregular schedule, or irregular hours rather, there's a great Q&A there that talks you through the math on exactly how you need to compute the number of hours they are eligible, right, for emergency paid sick leave and expanded FMLA. A couple of weeks ago, Mike Strasser and I gave some updates on this guidance, and we had a couple of slides regarding how you compute an employee's regular rate. So remember, the FFCRA ties regular rate to FLSA guidance and regulations, and so there's some really good examples to go through that, depending on what type of employee it is, if they're earning commissions or if they're piece rate, those types of pieces. And then talks also about what 6-month period should an employer use to calculate an employee's regular rate when the employee has been off using an FFCRA paid leave benefit during that time. So how do I figure those earnings into the regular rate for a new leave request? All of those examples are in that Q&A section, and rather than going through a hypothetical math example with you, I will just have you flag those. And I think it's really important when you get that leave request, go ahead and pull the Q&As up, work through the math with the information you have, and always feel free to reach out to your Miller-Johnson attorney, and we can help you walk through that as well. Next slide, please. The good news is the next set of questions, these last 3 questions, are non-math questions, and I think are probably more broadly applicable to all of us as we sit here and listen this morning rather than the math examples. So we'll spend a little bit more time on those. So question 86, when can an employer require an employee to use his or her existing leave policy, and when does the choice belong to the employee? So it's important for us to remember that employees always the employee may elect to take the employer-provided leave before emergency paid sick leave, right? But generally, emergency paid sick leave is in addition to any form of paid or unpaid leave you as the employer has, and an employer cannot require employer-provided paid leave to run concurrent with emergency paid sick leave. Expanded FMLA is a little bit different, right? The employer can require paid leave available to run concurrent with expanded FMLA. Remember, and certainly expanded FMLA runs concurrent with regular FMLA. It's a 12-week total bucket, and so you're running those 2 together. Expanded FMLA has the paid leave component for the one reason, right? Care of a child because of school or place of care closure. So it's important to understand when the employer gets to make that decision and when the decision is that of the employee. So question 87, the second bullet point here, and we've talked about this in previous webinars, when do shelter-in-place or stay-at-home orders qualify as reason number 1 under emergency paid sick leave? So remember, reason number 1 is a federal, state, or local quarantine or isolation order. And then if an employee is under one of those, a quarantine or isolation order that hits that threshold, that opens the door for their EPSLA eligibility. And so let's talk about when those orders can qualify. So generally, right, the shelter-in-place orders can fall into that category, but the distinction is really important, right? Remember that it's being subject to the order must be the reason the employee is unable to perform work that the employer has available for the employee. So in Michigan, right now, literally right now, the second, we have two types of shelter-in-place or stay-at-home orders. The one that we always think about is Executive Order 2020-42. That's the general one that talks about critical infrastructure, so on and so forth. So generally, that could qualify as reason number one under Emergency Paid Sick Leave Act, but only to the extent that the employee is challenging, right, that they are a critical infrastructure worker and they should not be required to come to work. Okay, so the general shelter-in-place order is not generally not an open door to reason number one under emergency paid sick leave. The other kind of stay-at-home order that Michigan has, EO 2020-36, that is the order that provides protection to employees who are experiencing any one of the main symptoms of COVID-19 or have a positive diagnosis or have been in close contact with anyone who has a positive diagnosis or is experiencing one of those main symptoms, provides protection for them to not work, right? It's an order for them to, if you fall in either of these categories, there's a protocol you should be following in terms of staying home, and it does not even require you, the employee, necessarily to seek a medical diagnosis on those pieces. So certainly, if your organization, right, you're a critical infrastructure employer, and so you are still running and your employees are coming to work, but now you have an employee who is experiencing one of the symptoms under EO 36, they're saying, hey, I can't come to work because this executive order requires me not to. That reason is a good example of something that would qualify as reason number one under emergency paid sick leave, okay? So an important distinction, particularly as we move forward and perhaps these orders continue to evolve and change. So the last question, the last updated question here, that third bullet point, question 88, written from the voice of the employee: what am I entitled to recover if my employer refuses to provide me with one of the paid leave provisions and the department brings an enforcement action? So I'll briefly talk about the remedies, but I also want to be clear on enforcement action. So if you remember, when the temporary final rule came out, the department indicated that there would be this temporary stay on enforcement actions through April 17th. And I will say, I was just reading this morning about some enforcement action that has happened nationally, and I will say that we have also heard from at least one client on some inquiries the Department of Labor has been making at that particular workplace in response to an employee reaching out. So the stay, right, when they talked about it, it was just being a temporary stay of enforcement, and that would be lifted on April 18th. That is certainly the case. So that's an important piece to remember. But particularly addressing this last point regarding remedies. So remember that the employee in that situation is entitled to recover the full amount they would have been due under either EPSLA or expanded FMLA, which is the greater of the employee's regular rate or the applicable minimum wage for each hour of uncompensated leave that was taken, subject to those FFCRA minimums. So in my opinion, I thought that was somewhat clear with the final temporary rule, but the department has felt the need to add it to a Q&A to make that a little bit more clear, and so that's important for us to know as we go forward. At this point, we'll go ahead and take a short pause and see if any questions have come in specifically on the FFCRA updates before we move on to EEOC updates. Cathy?
Thanks, Sandy. There have been a few questions. One is, will all employers need to post FFCRA notices, or only those who are covered by it? If you're not covered by the FFCRA, then no, you don't need to post a notice of it. Frankly, I think that would be confusing to employees if you do that. Second question is, in case you don't get to it, what is the recommendation of requesting medical documentation for those taking emergency paid sick leave? Does the employer have a right to a medical note? If you use the forms that we've created, we go through basically what you are allowed to ask and what you would need to have in order to have the sufficient documentation in order to obtain the tax credits under FFCRA. So that would include, you can ask for the name of the person's doctor. You can request a medical note, but as a practical matter, right now, you may not be able to get a doctor's note from an employee right away. So we're looking for a little bit of flexibility there, but you can get the name of the doctor who has issued any sort of quarantine order. Final question, we have a fit for work evaluation prior to reporting to work, COVID questions and a temperature scan. If they fail any of these, they schedule a telemedicine visit to get a return to work release. Do they qualify for EPSL or expanded FMLA or even unemployment for this period off work waiting evaluation? It may take 1 or 2 days to get released. So I think Sandy covered this somewhat. If you have an employee who has symptoms of COVID-19, like a fever or a cough, shortness of breath, then under Executive Order 36, they are going to be considered quarantine and entitled to emergency paid sick leave under number 1, under that first reason. They would not be entitled to expanded FMLA for that reason because one is not going to kick in within a day or two, and also because expanded FMLA, as you might recall, really is only for those caregiver provisions. So if you're caring for a child during a school closure, for instance. So hopefully that's responsive, and those are the questions that we have on FFCRA.
Excellent. Okay, thanks, Cathy. Next slide, please. Let's go ahead and move into some of the updated EEOC guidance document, and we'll go ahead and go to the next slide as well. So first, when we initially advertised for this particular webinar, we were talking about new guidance from April 17th, but as luck would have it, they issued some additional guidance just yesterday. And so, and some of you may have already seen that. One of the Q&As particularly is getting a little bit of press this morning, and so we'll specifically hit on that, of course. But wanting to give you a little bit of the framework. So if you remember way back when to March, right? If you remember way back when, 6 weeks ago, when this kind of started to hit, at least here in Michigan, in terms of making us all think a little bit more of this top of mind, the framework we were dealing with from the EEOC was really based on their 2009 influenza pandemic guidance, right? So we were pretty heavily reliant on that document to in applying to what COVID-19 issues may be similar there. So we've included the website for that particular guidance, but what is great here is that document has been updated, was updated on March 21st, and so all of the new 2020 information appears in bold in that particular document. So you'll still see, right, the website address talks about pandemic flu. So don't think you're going to the wrong place. That's the right place. And you'll see the COVID-19 stuff or any additional guidance they're providing there in bold. So that's a very helpful document to bookmark. But the second one that I think is particularly helpful and is more in a Q&A format that I really like is this technical assistance publication that the EEOC has put out, and there are several updates to this. There are 3 updates in the month of April alone. So that's another really good bookmark for you to have. And one thing that I like most about it is each of the Q&A questions have a date stamp of when that question was added or last updated. So I think that is particularly helpful for a couple reasons that will kind of become obvious as we continue through these questions. So next slide, please. So because I think some of these topic areas are more generally applicable to the entire audience, we're going to spend a little bit more time on these than the other 2 areas because I think it's important to see how the EEOC's view on these things is evolving and will continue to evolve as we all work our way through the pandemic and the different challenges that we face, right? So 2 weeks ago, right? The challenges were nobody is coming to work, we all have to be shut down, and maybe at least in some states, right, we know that some states are preparing to open back up for business, either in a limited capacity or a very broad capacity. So there's new return to work guidance that's been added and so on and so forth. So the big question that's getting a lot of press this morning is related to COVID-19 tests. So remember, under the ADA, disability-related inquiries and medical exams must be job-related and consistent with business necessity, right? Generally, we're limited to those inquiries or requiring those exams. But the EEOC is telling us if we apply that standard to our current circumstance of the COVID-19 pandemic, employers may take steps to determine if employees entering the workplace have COVID-19 because an individual with the virus would pose a direct threat to the health of others. So again, a couple weeks ago, we were just talking about taking temperatures, right? But now the EEOC is saying, okay, let's go one step above that. In the event that an employer had the ability to administer a COVID-19 test, perhaps that's a separate issue. But in the event that they did, they certainly are permitted to require employees to undergo that testing before they re-enter the workplace. So that's something really important for us to know as we think about transitioning back to in-person work. Now, we also recognize, right, that not all of us are kind of healthcare employers, right? So we can't just, tap one of our healthcare colleagues who's, right next to us and say, hey, you're going to be the one in charge of administering temperatures and the COVID-19 tests today, right? So it's important for us to know there are companies that provide staff that can administer those tests as well as taking temperatures, discussing symptoms. One of the questions Cathy just talked about was talking a little bit about a questionnaire, right, a symptoms questionnaire and making an evaluation. So there are companies that provide those services. Diversified Medical Staffing is one such company that we know some of our clients have worked with thus far, who have been wanting to implement this type of process in terms of making sure on-site work remains safe. So if that's not capacity that you have at your organization, but something you want to do, know those companies are out there, and Diversified Medical Staff is one of them. Okay, next slide, please. Quickly here, some information regarding hiring and onboarding. An interesting question that I saw here that I thought the answer was good and nuanced. So the question was, may an employer postpone the start date or withdraw a job offer because the individual is 65 years old or pregnant, both of which place them in a higher risk from COVID-19. So I'm sure Cathy would agree, but we've gotten variations of this type of question. Can I require all of my employees who are 65, to work remotely just because they're 65? And so the answer is no. There's some nuance here, right? So no, we're not going to postpone someone's start date or withdraw a job offer just because an employee falls into one of those categories, which of course are both protected characteristics under federal and state law, right? But the EEOC takes it a little bit further and says an employer may choose to allow telework or to discuss with these individuals if they would like to postpone the start date. So some recognition from the EEOC here, right, about the risk categories and how to traverse some of those conversations, right? And we again always encourage employer, let's not play healthcare provider here. Let's take the opportunity to engage in a conversation and evaluate from there. So that's good guidance to reiterate that from the EEOC. Next slide, please. The next couple slides deal with an employer's obligation for reasonable accommodation, right? So when you have an employee who requests an accommodation, we know that we have some requirement to engage in an interactive process to determine what accommodations might help that employee continue to perform the essential functions of their job, maybe even in a bit different way than they had, or an employee may without a disability, right? So some additional guidance here from the EEOC, recognizing that many of us are working remotely. So the question, in a workplace where all employees are required to telework during this time, should an employer postpone discussing a request from an employee with a disability for an accommodation that will not be needed until he or she returns to the workplace when mandatory telework ends. So recognition from the EEOC, you know, in terms of all of our HR folks and our company leaders who are dealing with a myriad of issues, where can I put these such requests in terms of the pecking order of my priorities? So the EEOC says, you know, we don't necessarily want to postpone that discussion, but it's perfectly appropriate for an employer to give higher priority to discussing requests for reasonable accommodation that are needed while teleworking, right? So it's important to, you know, deal with the hottest thing in front of you, but let's not kick the can down the road, because we all will be transitioning back to on-site work, and we want to make sure that to the extent we have the capacity to think through and work with the employee on that accommodation request, so we're all ready to hit the ground running as soon as we can return, that is ideal, and that is the recommendation from the EEOC. Next slide, please. Couple questions here specifically regarding the undue hardship standard. We generally know, right, that the employer is required to engage in that interactive process and consider an accommodation, and absent an undue hardship, we have a requirement, right, or responsibility to provide those accommodations. And we know that the undue hardship standard does take into account some financial and practical pieces, but the economic landscape has changed for many, many of us with the COVID-19 pandemic. So I appreciate, right, the EEOC factoring that piece into its analysis, and I thought a couple of these questions were particularly on point, and I found them pretty helpful. So, question here. Are the circumstances of the pandemic relevant to whether a requested accommodation can be denied because it poses an undue hardship? And the answer is yes. In some instances, an accommodation that would not have posed an undue hardship prior to the pandemic may pose one now. And so this is great, because I think it's a recognition, right, that the EEOC is saying, hey, it may be significantly more difficult for employers to conduct needs assessments or acquire certain items. Delivery may be impacted, particularly for employees who may be teleworking. So some of this calculus changes a little bit, recognizing some of the impact to our supply chains and things such as that. And so it's not, you know, we said this hit the undue hardship threshold. This exact same request wasn't an undue hardship 6 months ago. And so we don't want to say it must not be now. Again, we always go back to, we always want to make that case-by-case specific analysis based on what the employee is requesting, what that specific job is, what the financial circumstances of the organization are at the current time. So, so I found that answer particularly helpful, but essentially just reiterating that really important piece we already know, always case-by-case specific analysis. So next slide, please. Continuing on that undue hardship theme, what types of undue hardship considerations may be relevant to determine if a requested accommodation poses a significant expense? So remember, that's one of the criteria. The financial implication component is a potential criteria for an employer to evaluate an accommodation, and it may pose an undue hardship. So let's take a look at that specific during the pandemic. The sudden loss of some or all of an employer's income stream because of this pandemic is a relevant consideration, but even under current circumstances, there may be many no-cost or very low-cost accommodations. So the important takeaway here is, yes, we recognize the financial picture has changed, but this is not a free pass, right? We don't all get to say, you know, our profit and loss statement has taken a hit, so everything is an undue hardship right now, right? That's not what the EEOC is saying here, right? So we've got to look at the expense under the circumstances still must be significant, and the employer should consider other discretionary funds. For example, have you just received a PPP loan, a forgivable loan, right? That's important in this math calculation right here, as well as the likelihood of future improvements to the economic outlook. So are you operating in a state or locality where stay-at-home restrictions that particularly impact your business are ending or lifting? That's all really important to take into account. So again, the main theme is it's not a straight up across the board, always the same answer, always going to be case by case, fact specific, depending on the outlook at the particular time. Next slide, please. And lastly, hopefully this is something that we all get to have in the forefront of our minds really, really soon, right? If we look to when we start to transition back to in-person work. So how will employers know what steps they can take consistent with the ADA to screen employees for COVID-19 when entering the workplace? So we remember our previous Q&As talked about, administering COVID-19 tests is perfectly fine. In the context here, of course, as stay-at-home orders are modified or lifted, right, when does the direct threat go away? So if you remember, way back in the beginning of March, we were teetering on, is COVID-19 a direct threat to our workplace based upon where each of our localities stood in terms of community transmission, and there was a time that it didn't hit that threshold, but we've crossed over that threshold now. And so the question is, when does that threshold go back to that we're under it, right? That we don't hit that threshold. So the EEOC is reminding us here that direct threat is determined based on the best available objective medical evidence, and tells us, they point us directly to saying guidance from the CDC or other public health authorities is the objective medical evidence, excuse me, that employers should be using as their guide. And so I've included an additional link here that I think is really helpful, right? So recently, the CDC issued interim guidance for critical infrastructure workers, talking about when they are permitted to return to the workplace after an exposure or experiencing symptoms themselves. So certainly we're not all healthcare workers, as an example, or necessarily critical infrastructure workers. But as we look at stay-at-home orders lifting, that guide is a good indication of some things that those employers are having to think about in the way that the CDC is saying it's okay to administer those return to work programs now. So if we start to base some of our plans on those, that would be a helpful place to start. So with that, before we turn to talking about OSHA, I will go back to Cathy and see if any questions regarding EEOC guidance have come in, and if we have the ability to answer those.
Sure. I'm going to back up because there were a few questions that came in about those forms for FFCRA that I had referenced. I believe that there is a link to those forms on our website. But if not, then we'd be happy to provide them if you want to follow up with your email and that sort of thing. Moving on to the EEOC guidance, we have one question from a person who provided a hypothetical situation where we have a current employee who is 65 plus, and when we reopen our office, they don't want to come in because of fear of catching the virus, despite our extensive cleaning and safety protocols. The employee's position is not something that can be done from home. What are our options? That's a really good question, and it's one that we've been getting a lot. I think step one is, communicating to the employee what you have been doing to make the workplace safe for them and what your safety protocols are. Also communicating why their work is so critical and why it's important that they show up. The second issue is unemployment, right? A lot of employees have wanted to choose unemployment rather than coming into work because they can make more money. There was a webinar that directors from, I believe, Laura and definitely the unemployment agency participated in, where a very similar question to this was asked. It was, basically, if an employee is fearful of coming into work, does that mean that they would get unemployment? And the answer was clearly no, that if an employee is immunocompromised or elevated risk because of that reason, then they would be eligible for unemployment. But if it's simple fear of contracting COVID-19 that's prohibiting them from coming into work, that's not going to be good enough. So I think, laying out some of the consequences of an employee not coming into work, can be helpful in encouraging them to return. Another question that came in is, are there any legal implications with mandating that employees wear masks? I would say typically no. You can require that employees take additional safety precautions. The only caveat I would make is that if you had an employee who, had some disability and, as a reasonable accommodation, they felt that they couldn't wear that mask or that was somehow harmful to them, you would want to talk through that process, that there was some religious issue or some protected characteristic that an employee wanted to talk through with you about why they can't wear the mask, then, you would want to at least participate in that process. Another question that came in is whether temperature checks on visitors would be permissible. I don't see why not. Presumably, if you're a private company and you have private property, if a visitor comes onto your property, you could treat them, similar to the way that you treat employees. So I don't see any legal reason why you wouldn't be able to do that. And with that, I will turn it back over to Sandy to talk about OSHA.
Excellent. Yes. Turning back to our next slide, please. There you go. Our OSHA documents. So go ahead and go to the next slide. So as luck would have it, we've got breaking news this morning that the governor has just made some changes, right, to Executive Order 42 and has issued an updated executive order. We will be reviewing that and sending information out to you about what we know on that. But generally, I will just say that 42 has now been replaced by Executive Order 59, and there are some changes there. But generally, let's go ahead and talk about some OSHA requirements. So for anybody who is on the call who is currently conducting in-person activities, you already know a little bit about some of the OSHA guidance documents, right? Because under Executive Order 42, any business that was continuing in person was required to develop a COVID-19 preparedness and response plan that was consistent with the recommendation in OSHA's guidance on preparing workplaces for COVID-19. So we've included the link to that document here. Certainly for those who are doing in-person operations, you already know a little bit about this, but for those who are not, this is a good place to start, right, as we start to think about returning to the workplace. So rather than going through what the plan needs to consist of, I will just point you to, we did a webinar last week discussing some of the OSHA and CDC components that make up a great plan, and we provided a recommended framework on what a preparedness plan could include. So I'll point you back to that for some of the nuts and bolts on what a plan needs to look like. But just to center ourselves on what some of the OSHA guidance documents look like, that's one several of you may already be familiar with. Next slide, please. So also just wanting to bring to your attention some of the other documents that are out there that I find particularly helpful. So we've included the link here to OSHA's news update page where they post alerts, enforcement guidance, various pieces of guidance. And so that's another site to go ahead and bookmark and check back often. A couple of the alerts that I find really helpful, they do alerts specific for certain industries or types of work. And so the alerts that currently exist out there specifically are addressing COVID-19 guidance for the construction workforce, manufacturing industry workforce, package delivery workforce, retail workers. Generally, those documents contain very, very similar information to what is contained in that larger guidance on preparing workplaces document. But I like the industry-specific guidance because I think it does a really good job of identifying specific challenges that could be unique to that particular workplace or type of work. And quite frankly, from an employer standpoint, it's really nice to rely upon those, right? If you've got the federal Safety and Health Administration saying these are the things we recommend and you're doing all those things, that's a really great source of comfort to your employees, right? And to you, that you go, okay, there isn't something else out there that I haven't thought of that we should be doing. This is a really nice place to take a look at some of those things and take a look at some opportunities you have for continuing some of that work. Next slide, please. The next section on that news release page deals with enforcement memoranda. So the intended audience on these documents is not necessarily employers, right, but rather OSHA or state plan designee enforcement personnel, right? So it's the federal agency telling their own enforcement personnel what, if any, adjustments to the, quote unquote, regular rules related to various enforcement activities make sense based on the current state of the world. And so obviously we know our world has changed in the last 6 weeks, and so there have been a number of enforcement memoranda put out here. I've just listed a few on this slide. There are many, many more than this. Excuse me. And these are all, of course, time limited to our current public health crisis. So these sunset, right, as soon as we are through this and we go back to whatever those regular rules were. So I'm just going to quickly hit on a couple of these. Recording cases of COVID-19. So we did a client update on this topic, and that's on our website if you want all the nuts and bolts about what this is. But essentially, right, we know that we have an obligation under the safety and health regulations that when we have a work, I'm speaking broadly here, but when we have a work related injury or illness that has resulted in either a certain type of injury or level of care, right, it goes beyond, general first aid, we have a requirement to record that and report that appropriately. So the updated recording guidance essentially is saying, hey, we recognize that it's going to be very difficult for employers to make a determination about their employees who may contract COVID-19, whether that was work-related or not. And so it essentially is saying that unless you are a healthcare employer, an emergency response employer, or a correctional institution employer, we are generally going to make a presumption against work-relatedness for reporting purposes unless very specific circumstances exist surrounding your employee's positive test, right? So again, that's generally what that enforcement memoranda says. I'll point you to the client alert for all of those pieces for more information there. And of course, you can go right to the OSHA documents as well. But that's generally what the update is there. Annual fit testing in healthcare and all other industries. So we know, right, if you are requiring masks that fall under OSHA's respiratory protection standards. Fit testing is a requirement of those standards. And so here, this enforcement memoranda is telling us that the field offices should be exercising discretion concerning the annual fit testing requirements as long as employers have made good faith efforts to comply with the requirements of the respiratory protection standards. Generally, are using properly certified respirators, are implementing CDC and OSHA strategies for optimizing the supply of N95 respirators, are performing initial fit testing, are educating their employers, their employees that they have temporarily suspended annual fit testing, explaining to the employees the importance of the employee performing that seal check and conducting a fit test as appropriate, and certainly if an employer observes visual changes in the employee's physical condition that could in fact affect respirator fit, the employer still should be doing that fit testing. And then of course, educating your employees, reminding them that they need to inform a supervisor if they feel the fit of their respirator has been compromised. So that's just a very general overview on what that update is. The next piece, use of respiratory protection certified by other countries. So generally, under the OSHA standards, the respirators that are permitted are respirators that have gotten the NIOSH seal of approval, right? But OSHA here recognizes shortages, right? And additional supplies might not be available that have been NIOSH certified. And so OSHA has provided a list of countries or regions and very specific models that they say for the time being, if you can't get a NIOSH certified respirator, but you can get one of these other respirators, that is going to comply with our standard for NIOSH certified equipment. Again, this is very high level, and I'll point you back to the OSHA specific document on these things. And the last piece, talking about considering an employer's good faith efforts to comply with OSHA mandated training, audits, and assessments, inspections, and testing. So essentially, right, OSHA is saying that we know our regulations require employers to train and to audit and to conduct inspections on equipment and to test equipment and so on and so forth. But we also recognize, widespread business closures, restrictions on travel, stay-at-home orders. And so several employers and any consultants or contractors, right, that they may hire to perform those activities may have been hampered, right, by the pandemic. So OSHA is telling its enforcement team that the team really needs to look at the employer's efforts to comply with the standards on training and reviews and audits and assessments, and that where compliance is not possible, it's important for the enforcement officer to look at what steps the employer has made to be sure that employees have not been exposed to hazards from tasks or processes or equipment that they haven't been trained on. Those officers need to be looking at whether the employer has explored all options to comply with the standard. If it's training, as an example, has the employer considered doing virtual training, and would that be effective training? The enforcement officers should be looking at what interim alternative protections the employer has implemented. So for example, have you taken a piece of equipment out of service until it can get inspected, subject to an annual inspection, and so nobody is coming in contact with it? Have you instituted any additional engineering or administrative controls to make sure that no employee is being exposed to a hazard because of our inability to do those regular assessments, those types of pieces? And then, of course, the enforcement officer should also be looking at whether the employer took steps or is taking steps to reschedule those required activities as soon as possible. So all of those pieces kind of go into the calculus, right, for the enforcement officer to determine, okay, you haven't been able to complete your annual training, but here's the circumstances of why, and here's all the things that you did to make sure your employees are getting the training as soon as possible, and the steps that you took to make sure that no employee has been exposed to a hazard as a result of the lack of that training. So, so that's important for all of us who are operating equipment or dealing with employees, right, dealing with equipment or certain pieces under the OSHA regs that may require some of those annual tasks. Knowing how OSHA will look upon our inability to comply with those is important. And the next slide. So this is not new, but this is something to kind of file in the back of your mind on something that could be new. HR 6559 has been introduced at the federal level, of course, we're talking here, and it's called the COVID-19 Every Worker Protection Act of 2020. And essentially what this bill does is saying, hey, OSHA, right, through the Secretary of Labor, because that's OSHA reports, right, is a part of the Department of Labor broadly. So it's saying, hey, Secretary of Labor, this COVID-19 pandemic, you're required to issue some kind of temporary standards that specifically talk about some of these specific occupational safety and health situations or circumstances that are going on right now, and issue some specific regulations that employees and employers must abide by. So that's essentially what this bill is doing. There's nothing particularly specific in the bill other than it's directing the Secretary of Labor to issue that emergency standard within 7 days of that bill being enacted, and it would require the Secretary of Labor to go through, informal or formal rulemaking and finalize the standard within 24 months, so 2 years of the enactment of that bill. And essentially, again, like I said, would require businesses to take various actions designed to protect workers that are specifically geared towards a novel pathogen, right, that like we are dealing with right now. So again, nothing for you to know about this right now other than know that there are, there are conversations going on at the federal level pushing OSHA to do this, and so we will be monitoring that very, very carefully as we go forward if that comes to fruition. Okay, so with that, I will turn it back to Cathy, and if there have been any additional FFCRA or EEOC questions that we can tackle at this point, I will let you address those.
Okay. One question that we had was back to the FFCRA, how does it work when you have an employee who, may have been using time off to care for a child due to a school closure, and then develops symptoms of COVID and has a fever and is seeking a diagnosis to determine whether they have COVID. And the question was sort of how do those interplay? You can have an employee go back and forth between different types of leave, and the significant impact of going from a child care-based need for leave to one where it is for the employee's own diagnosis or care is the pay, right? So, when the employee was taking FFCRA covered leave to care for his or her child because school was closed, they were only getting 2/3 of their pay for that time period. Once they've developed a fever and are seeking their own diagnosis, one, they're going to be prohibited from coming to work, most because they have symptoms of COVID under the Executive Order 36. So they'll be covered under that, and they also may be covered under the having symptoms and seeking a medical diagnosis. Either way, with that reason for leave, they're going to be entitled to 100% of their regular rate as opposed to 2/3. So, there may be times where, the employee is going back and forth between different reasons for the leave, and so pay may change, but the amount of leave does not, right? So regardless of why the employee is gone during that, first 2 weeks of leave when it's emergency paid sick leave, those days are going to count together. So it's not as if the employee is going to get 2 weeks of time off for their own condition and then 2 weeks of time off of emergency paid sick leave to, for a different reason. Let's see. Oh, another person asked what agency webinar made it clear that if an employee is afraid to return to work, that they won't be eligible for unemployment, and asked if the same was true for those who don't want to return because they're making more on unemployment with a $600 additional federal payment. So to your first question, I can find that link to the webinar. I believe it was on the unemployment agency's site. I know that it was Director D'Onofrio who made the comments. So I would have to find it, but it was very helpful, and I remember it was like around the 11-minute mark when he said it. I don't know why I remember that, but I do. With respect to the second question, you know, when you're dealing with an employee who just doesn't want to return because he or she is making more money on unemployment, I think that's an easier situation to deal with. In fact, the federal government has directed the state that, you know, they are not to be paying claims when an employee has work available and could go to work but is choosing not to, because essentially that's unemployment fraud. So there is actually a written directive from the Department of Labor to the State of Michigan Unemployment Agency saying that. So you know, that can be helpful to show to your employees also if they think they can just stay home so that they can get additional enhanced federal unemployment benefits.
And a couple OSHA-related things, Cathy, if I can jump in here. So from an OSHA standpoint, right, if we have an employee who is refusing to come to work, and I think Cathy hit on this, but just to reiterate, I think in terms of how you analyze that, the reason the employee is refusing to work or refusing work that you have available is really important, right? So it's important for you to understand what the reason is and evaluate whether that reason implicates any area of federal or state law that the employee has protection to refuse that work, right? And so from an OSHA and my OSHA standpoint, right, here in Michigan, our state plan is OSHA plan is administered by my OSHA, right? That standard is imminent danger of death or serious injury or illness. And so certainly COVID-19 is a serious illness, but again, like we've talked about with some of the EEOC pieces and requests for accommodation, it's going to be a fact-specific kind of case-by-case analysis. And all of the safety, right, the social distancing and mitigation strategies that you are implementing in your workplace are going to be really important for you to form that analysis, right? So, you know, it's just, is it a general fear because there's community transmission despite the fact that my employer is doing all of these things and following, you know, the OSHA guidance for workplaces document to a T, and they've got the preparedness plan and they're following that to a T, and they're limiting access and doing remote work, and they're temperature checking and doing health assessments on everyone who comes into the building, right? All of those things are more helpful for you, right, as you consider, you know, the reasonableness of the employee refusing that work. And so obviously there's a number of other federal and state statutes that could provide protection there, but from an occupational safety and health standpoint, that's kind of the analysis. And I just wanted to circle back and address one more question regarding masks and mandating and voluntary and all of those pieces. And so certainly, as Cathy mentioned, no issue with you requiring an employee to wear face masks when they return to the workplace. But from an OSHA standpoint, depending on the type of mask, right, you may then be falling under some OSHA requirements, OSHA's PPE or personal protective equipment standard, or OSHA's respiratory protection standard. Generally, the respiratory protection standard applies to like N95 respirators and not just your general cloth face mask. But again, I'm speaking at a very general level here. If anyone has a specific question, please reach out to us and we'll go through the analysis with you. But generally, even falling under the PPE standard, right, we want to make sure that we're doing some kind of, as Cathy mentioned, a hazard assessment, right? So, you know, by mandating employees wear these face masks, have I just subjected them to another hazard in the workplace, right? Do we have some machinery that face mask could get caught in, and what additional things am I doing to make sure that that doesn't happen? If it's PPE, then I need to train employees on how to use it and care for it and keep it clean. You know, I might need to be doing that. Is the PPE I'm providing appropriate? All of those pieces. So certainly, as Cathy mentioned, you absolutely can require your staff to wear masks once we get back to in-person work, but it's important for you to understand that by making it a requirement, you then have some obligations to do some things there, and so it's important for you to understand those obligations. Again, if that's a particular consideration, go ahead and reach out to us and we can walk you through that analysis.
Yep, great point, Sandy. And with that, we promised our IT superhero that we would make sure that we ended this webinar by 11 o'clock. With that, I think we're getting it just under the wire, but we appreciate your participation and hope you all stay safe and healthy.